We want to kick it off right now. Our top story this hour. Special counsel Robert Mueller issuing a grand jury to investigate Russia's alleged meddling in the 2016 presidential election. This is according to the Wall Street Journal this morning. Reuters is also reporting that grand jury subpoenas have been issued in connection to the meeting between Donald Trump Jr. and a Russian lawyer last year. Joining us right now to talk more about it is the former Whitewater independent counsel and Thompson & Knight partner, Robert Ray. Good to see you, Robert. Thanks so much for joining us.
Good morning.
So Mueller now has a team of 16 attorneys on this investigation. Why would he impanel a grand jury?
Because that's what you do. I mean, you have an investigation, you have an investigatory grand jury. It's not entirely clear to me whether he's using it at the moment off the rack, a grand jury in the District of Columbia, or whether he went, as the Wall Street Journal reported, to the chief judge of the U.S. District Court for the District of Columbia to impanel a special grand jury. But either way, it's consistent with his hiring decisions. He's got 16 people in place. You impanel a grand jury to hear evidence in the case on a going forward basis. That grand jury typically will last from 12 to 18 months in the ordinary course. You want that grand jury to last during the course of your investigation. What it means, bottom line, is that this investigation is going to last well into next year.
But what does a grand jury allow Mueller and team to do specifically?
Anything from the ministerial, which is the issuance of a grand jury subpoena through the U.S. Attorney's Office, or in this case the special counsel as the agent of the grand jury, to the taking of testimony, to, in more significant situations, going before a district court and getting an order compelling someone who otherwise refuses to testify because of the assertion of the Fifth Amendment privilege, to ultimately, the penultimate job of a grand jury is to decide, once the special counsel decides to move forward, whether an indictment of an individual or individuals should issue, meaning that a grand jury has made a determination that probable cause exists, that a crime has been committed, and that the person named in the indictment or charge has committed it.
But you feel that this is normal practice? This
Absolutely.
is what you do?
I was appointed in October of 1999 as the independent counsel to replace Ken Starr, and by the summer of 2000, I had a specially impaneled grand jury in the District of Columbia whose sole purpose was to consider whether or not charges involving the President of the United States were appropriate once he left office.
And you were actually the victim of a leak, were you not?
I was. I mean, I was on vacation in Nova Scotia, returning to the United States at a time when, you know, we had pagers and less sophisticated electronic devices, and you didn't always have cell coverage every place. The minute I entered into Maine, after the end of my vacation, every electronic device in my vehicle went off at the same time. And so I knew that was trouble. And the trouble was that it had been leaked into the media right at the time of the Democratic National Convention, when Al Gore was nominated by the Democratic Party to be the next president of the United States. And it was disclosed at that time that I had impaneled a grand jury in the District of Columbia.
That was the leak. That was
the leak. And so we spent the next frantic few days after that trying to figure out where the leak came from. I mean, I didn't leak it. In fact, I was snuck into the courthouse in D.C. all the time to avoid just that sort of media disclosure about the existence of grand jury proceedings, and I had intended to keep that secret.
Can you say who it was?
And it turned out to be one of the judges on the three-judge panel, the special division in the District of Columbia.
He was the leaker?
He was the leak. He leaked it to the media.
The judge?
The judge, Judge Cudahy.
Wow.
And David Santel, who was then the presiding judge, he still sits on the U.S. Court of Appeals for the D.C. Circuit, as does Judge Cudahy, by the way, basically issued an ultimatum: you will disclose the fact that you were the leaker, otherwise I will.
Wow.
And that's how it was confirmed. But I mean, it was a terrible few days where, you know, everybody from Dan Rather on down were complaining about the fact that, you know, Robert Ray, the independent counsel in the Whitewater investigation, had leaked to the media in order to affect the political process, and Al Gore's big night.
Wow.
Until it was revealed that I wasn't the source of the leak. One of the judges on the special division was.
What do you think about the leaks in the White House?
It's trouble. I mean, it makes it very difficult to do what you do. But look, that's the job of an assertive chief of staff. I mean, that's what the chief of staff is supposed to get a hold of. Now, look, you're never going to be able to entirely eliminate leaks, and even, you know, there are leaks of the kind that are politically damaging, and then there are also the leaks that actually happen to be a violation of law involving national security information. But either way, leaks make it more difficult. Every president has found this. You know, Barack Obama did too. I mean, nobody likes George Bush. all the way back to Bill Clinton, as far as I can, in the modern era. With 24-hour news cycle, there's a great demand for just that kind of information, but it's very damaging.
Yeah. And all indications are that the new White House Chief of Staff, John Kelly, is really putting the hammer down.
He's on the warpath, as he should be.
Even the New York Times has a story about that very thing today, that if staffers are lingering when they shouldn't be in high-level meetings, he shoos them. The doors to the Oval Office are closed so people don't stray into the Oval Office. Again, it's not loose anymore. He's really,
well, look, I was
really
the most relieved person in America to find out that my office wasn't the source of the leak. If it, obviously, if it had been,
because you don't know.
That you don't know. You never really know,
Right.
and the damage that can be done in terms of undermining public sentiment in favor of the completion, responsible completion of your work is the kind of damage that is not easily recovered from.
Robert, you're saying too, with this investigation, that this could go into next year. So
yes.
Whether information gets leaked or not, what are we expected to find out during this time? What can we expect to hear?
It's a great question, and it's sort of a mixed answer. I mean, there's nothing that prohibits a lawyer for a person who receives a subpoena or the person who receives the subpoena, him or herself, from disclosing to the media the existence of that subpoena and the fact that they've testified. And you remember the parade of witnesses before the grand jury during the Clinton era. Many of them came right out after they testified, including Hillary Clinton and others, in front of a microphone to say, I just appeared before the grand jury and this is what I said. That's permissible. What's not permissible is for a prosecutor or anybody in the prosecutor's office, including agents of the FBI and others, to disclose under penalty of prosecution.
What about a judge? Penalty of prosecution?
Well, that was an open question at the time.
You said he's still on the court.
He is.
The leaker.
We were very unhappy to hear about that development in one way. On the other hand, again, I was the most relieved person in America when I found out that it wasn't my office that was responsible for the leak. And we recovered from that, I think, nicely. I was able to continue to go on and do my work. But you can imagine, what the alternative would have been if the leak had been found to have been within my office. And you know what? It's entirely possible that that's the case. But to answer your question, with regard to critical decisions, knowing how Washington works, there were things involving, for example, negotiations with the president where I didn't tell anybody in my office other than the people that I really felt had to know. My deputy, my chief of investigations, and me. That was it.
And you still had a leak.
Well, not with regard to the matters involving the resolution of the case against the president. That was one instance where, because it was so tightly controlled, I was able to prevent that from being disclosed. But, that took an extraordinary action, and it was at the penalty of, ordinarily you would want a full discussion in the office about those sorts of things, which in other matters you did, but I didn't do that because I knew that if I did that, the likelihood that it would dump out into the public was certainly significantly greater, and a risk that I wasn't prepared to take.
By the way, let me state the obvious. With all of these leakers around the White House, if there was this much evidence of collusion between Trump and the Russians, it would have leaked.
We'd already know about that.
Give me a break.
Yeah, I think, hello, it's Washington.
That leads to a follow-up. What do you expect to come out of this investigation?
Well, I think the next thing that you'll see, we'll get some outward manifestation probably the moment that witnesses start to go before the grand jury. I mean, I think at this stage we're conducting the preliminaries and the ministerial things. They're gathering records, they're finding out and getting the text messages and the phone records and the emails and so forth from the service providers, the internet service providers and otherwise. All of that information will be gathered. And my guess is fairly quickly thereafter, if the subpoenas haven't gone out already, you're going to see witnesses go before the grand jury. Some of them you'll know about. Obviously, some of them you won't. Yeah. But, again, we will have some, I think, outward manifestation of what's going on. Not a complete picture, obviously, because matters are conducted in secret, but not everything's secret.
Yep. Just think about the time, the resources, the cost that is going to go into this.
Tens of thousands of dollars.
People forget, look, when you take one of these jobs, you have a piece of paper which is your mandate. You start with nothing. Not a paper clip, not a legal pad, no staff, no FBI agents, no prosecutors. All those things have to be assembled first before you can do the work of the investigation. The mistake I think that had been made in the past was too long was spent in the ramp-up period. And I think Bob Mueller knows that, and by reputation, he's not wasting any time.
Yeah.
I mean, he intends to get to this, I think, and from what people who have worked for him previously have told me, they expect to get to the finish line next year.
All right.